Conyers, photo, J. Scott Applewhite/AP. Washington. The resignation of longtime U.S. Rep. John Conyers a week ago means that those who accused him of sexual misconduct likely won't get to testify before Congress or get their day in court, legal experts say. The sexual harassment accusations are from 3 to 20 years old, so the statute of limitations long ago expired under the Congressional Accountability Act, which covers employees of the U.S. House of Representatives. The House Ethics Committee also is widely expected to close its Conyers investigation, since its jurisdiction doesn't extend to former members of the U.S. House, but legal experts said accusers can continue to speak out in an effort to reform congressional harassment review rules. Conyers, a Detroit Democrat, resigned or retired last week after nearly 53 years in office, while vehemently denying the allegations made by former female aides. The 88-year-old former lawmaker said the accusations were not true and part of the game of politics, while adding that I can't explain where they came from. The lawyer for one of the women who accused Conyers of sexual harassment had said her client, Marion Brown, would testify before the ethics panel, but she has not heard back from committee staff. That's unfortunate, because my client Marion Brown and the other women who signed affidavits with similar stories want to be heard, said attorney Lisa Bloom, whose client in 2015 accepted about $27,000 in a confidential settlement that Conyers paid from his office budget while denying the allegations. She and Brown will be in Washington on Tuesday to advocate for reforms so that no congressional staffer with a harassment or discrimination claim will have to go through the ordeal Marion endured, Bloom said. Conyers' attorney, Arnold Reed, questioned Brown's credibility by saying people would come forward saying these allegations are untrue. Conyers told the Mildred Gaddis radio show there should be complete public disclosure of congressional harassment settlements to reveal to all the citizens of the country of what the federal legislators are doing or not doing, and any cost that may have been incurred as a result of that. The Ethics Committee has, at times, kept open an investigation after a member stepped down. But those cases typically involved a broader issue, such as oversight of the House Page program raised by the 2006 case of former Rep. Mark Foley of Florida. Another possibility that could extend the probe is if the panel were to uncover evidence that others were complicit in unethical activity related to Conyers, and those people still work for the House, said ethics expert Meredith McGehee, executive director and head of policy at the nonpartisan group Issue 1. My expectation, given their record, would be is they would consider this a closed matter once Mr. Conyers was gone, McGehee said of the Ethics Committee. Even if someone wanted to try to take him to court outside of this, as a civil matter, that would be hard to do given the way the Congressional Accountability Act is written. Ethics lawyer Melanie Sloan, who says Conyers verbally abused her when she worked for him in the mid-1990s, said she would be shocked if the Ethics Committee takes action at this point.